Good morning and welcome to this second in the series of Travers Smith and Tech UK Data and the Digital Economy webinars. This morning we're looking at the auditing of AI and algorithms and how to best prepare for the future. Now, what links exam results, legal due diligence, credit and lending decisions, the making of recruitment decisions, what we watch on Netflix and what we read on Facebook? Well, all of them are determined to some extent by algorithms. And today we're going to be looking at the law and regulations, as well as the ethics to be aware of when using AI and algorithms in our businesses. We're going to look at how that should translate into a compliance model for businesses. How much should boards and C-suite executives know about the use of algorithms and AI within their businesses, and how to explain the use and also to deal with any complaints that might arise from the use of AI and algorithms in a business context. Now, this is obviously a very topical area and one in which there is great interest, and many different organisations are thinking very hard about some of the questions that we will be touching on this morning. So the UK Competition and Markets Authority launched a consultation last month on algorithms, competition and consumer harm. There's obviously been recent court cases, including one in Italy, which was about the allocation of shifts and potential unfair bias or discrimination in the case of Deliveroo drivers. Obviously, we've got the UK budget coming up next month, and we read that there's going to be a refreshed or renamed industrial strategy, but AI and algorithms will be very much a part of that. And the UK, of course, sits third in the Global AI Index, which looks at the level of investment, innovation and implementation of AI in countries around the world. And I say the UK sits third, which obviously provides huge business opportunities for us. And we've got some fantastic speakers for you this morning. We're going to start off with James Longster, who is a partner in the Travers Smith Commercial IP and Technology Department. He specialises in technology, data protection and intellectual property matters, and clients including both sellers, purchasers and developers of technology solutions, and he's got a particular interest in emerging tech. And then we want to provide you with a very practical example of the use of an algorithm in business. So we're delighted to be joined by Sean Curran, who's the head of legal technology at Travers. His team includes individuals who've got a background in either technology or law, and they're responsible for delivering technology-driven efficiency and optimization within the firm's legal practice. We're also delighted to be joined this morning by Alistair Pearson, who's going to talk about why the ICO is interested in AI auditing, how they define AI, and why it doesn't really matter. Alistair is a senior policy officer in the technology department at the ICO, and he joined in January last year to support the work of the ICO on the AI auditing framework. And then our final speaker is Maria Acciente from PwC. She is the head of the lead for responsible AI and AI for good lead at PwC, and advises clients and partners across industry, academia, governments and more on how to harness the power of AI in an ethical and responsible matter. She's got a very distinguished list of achievements. She is a globally recognised AI ethics expert. She's an advisory board member of the UK Government All-Party Parliamentary Group on AI. She's vice chair of Tech UK Data and AI Leadership Committee, and many other things as well. So it's fantastic to have all of our speakers here this morning. So without further ado, James, I'm going to hand over to you for your remarks. Thank you.
Great. Thanks very much, Nikki. So as Nikki was saying, in this section of today's webinar, I'm going to be looking at what you should be considering from the legal perspective when you're looking at implementing algorithms and similar technologies. Now, I'm getting asked more and more often by clients what laws apply to algorithms, and the answer is multiple and that they are varied. So the key thing really to remember is that there's no law of algorithms per se. So we need to look at the context of their use to understand what laws are relevant. And with that in mind, I'm going to concentrate on two main areas of law where we frequently see businesses facing difficulties or needing guidance, being the law relating to equality or discrimination and the law relating to personal data. I'm also briefly going to touch on supply arrangements for these types of technologies, as these three topics are likely going to be the key areas that will need to be looked at in any form of legal assurance or audit program. But before I do that, as a slight aside, I think it's important for us all to remember that the code and the logic that sits behind these technologies is the same really as any other proprietary software, and it can be protected by copyright. So it can therefore be a valuable asset within your business. So please don't lose sight of that if your business is developing these technologies. So let's talk about equality and discrimination, which primarily in the UK means the Equalities Act 2010. So the Equalities Act seeks to protect people from discrimination, and this protection extends to where that discrimination has been caused by a technological solution. So we typically see this issue cropping up in two main situations. So firstly, as Nikki was mentioning earlier, in an employment context, so any form of technological solution which was used to, let's say, filter candidates for a job or appraise an individual's performance in the context of a promotion could be contrary to the Equalities Act if that technological solution was itself causing discrimination. So there are many ways that that could arise, but one of the most common that we see in the AI context is where that data set that has been used to train the AI is itself in some way biased. So if you put bad data in, you're going to get bad decisions effectively. But it's important to remember that the Equalities Act doesn't just apply in the workplace. So it applies much more broadly to things like the admission of students to schools or the admission of prospective members to societies. And importantly, at least for my practice area, the provision of services to customers. And whilst those first two examples clearly have real world impacts, it's the latter where I personally see an uptake in the use of technological solutions and therefore a risk of contravening the Equalities Act. So Section 29(2)A of the Equalities Act states that a service provider must not discriminate against a person when it's providing a service by reference to the terms on which the service is to be provided. So a really good example here, although not decided on the basis of the Equalities Act, would be the fact that lower car insurance premiums for women solely on the basis of their gender is discriminatory. Now, what's critical for everyone to understand in relation to these technologies is that they aren't a silver bullet to rid your organizations of these issues. Now, I frequently hear people talking about the fact that they're de-risking the situation by moving their processes and procedures to a particular technology rather than a human decision. But in actual fact, I think what we're really doing is moving the conversation to a new medium. So organizations need to, they can't be complacent on this front. So in terms of a risk management perspective, it's going to become increasingly important for you to be able to demonstrate the steps from a legal perspective that you've taken at the design and, if relevant, learning phase of these technologies, so that if you're questioned in the future, you can confidently and accurately show your workings effectively. So reverse engineering these matters, or having to scramble around looking back at your notes, or worse still, saying you simply just don't know isn't going to cut it, and it's always going to put you on the back foot in any dispute. So moving on to the use of personal data under the UK and EU GDPR. Now, I'm not going to go into a huge amount of detail on this, given that we're lucky enough to have Alistair from the ICO here, who can discuss the ICO's approach and the really very helpful literature that it's put out. But what I will say, and this is something that I always advocate in relation to data protection issues, is to really go back to basics. And I think what that means here is that your processing of personal data needs to be lawful, it needs to be fair, and it needs to be transparent. So taking those in turn, firstly, you're going to need a lawful basis for each type of processing activity that you're undertaking. Now, that could be consent or performance of a contract or legitimate interests, although obviously with the latter, you've got to apply the appropriate balancing test to ensure that the legitimate interest in question isn't outweighed by the rights of the individuals. But as always, you need to ensure that you're looking at the processing on a process by process basis. So to give a high level example focused on AI, you need a lawful basis for both the processing of personal data by an AI technology to make a decision, and also for the training of that AI when it's using personal data. Now, it may well be that you end up with the same lawful basis for both, and that's obviously absolutely fine. But you need to have gone through the thought process independently in respect of each. And of course, you also need to be particularly careful if you're looking at special category data, not least because the lawful basis of legitimate interests won't be available to you in that circumstance. So the second thing I mentioned was that the processing needs to be fair. So for example, will the technology be processing personal data in a way that an individual wouldn't reasonably expect? And as an aside, I think it's fair to say if the processing in question breaches the Equalities Act, it's going to be pretty likely that it's also going to fall foul of the fairness principle. And finally, you need to be transparent. So make sure that your policies and your information notices reflect what's actually happening, including whether the technology in question results in a solely automated decision-making process where under the GDPR, you're going to need to, amongst other things, allow the individual the ability to contest the decision that's been made. Now, as I always say to clients, your privacy notices are what you tell the world, but it's equally important to keep your record of processing activities up to date and to also document the decision-making process that went into the process behind the personal data aspects of the use of these technologies. So a data protection impact assessment is a really good way of doing that. If nothing else, this keeps you honest. It forces you to challenge your views and identify particular risks. But importantly, in the context of today's session, this is ultimately what forms the bedrock of any subsequent assurance program from a data protection perspective. Now, I said I wanted to touch on suppliers as well. So third-party suppliers who are supplying these types of solutions to your organizations. And from a legal perspective, as with any supply arrangement, you obviously want to make sure that your organization is protected to the extent possible. So on top of all the usual legal provisions you might ordinarily want to include in a contract, you're going to need to potentially think slightly outside the box. So if you're engaging a third party to use AI to filter through applications you have for a job opening, which is obviously the example I mentioned earlier, it would be beneficial to get contractual comfort around the data set that the AI has been trained on and the Equalities Act implications of that. Another point to look out for in the context of third-party technologies is ownership of data, and where you're going to be training an AI technology for your own use, your ability to move between suppliers. Now, this might not always be technically possible, and it quite often isn't, but it's a really important commercial decision to be made at the outset before you put all your eggs in one basket and start spending time and resource in training a system for your own needs. So I appreciate that's a fairly whistle-stop tour through what I consider to be the legal considerations relating to these technologies, which I think personally are key in any assurance or audit program related to them. But I think the really important takeaway from a legal perspective is that you can't put these technologies in a neatly ring-fenced legal box. So as I said at the outset, there's no law of algorithms. And there are other laws, in addition to what I've mentioned today, which may be relevant to your use of technologies. So you've always got to place them in context. So from a legal perspective, I think the main difficulty will always be applying the use of the relevant technology to the legal framework in which a business operates, and then assessing those relevant risks. So, those aren't new skills for lawyers, but as lawyers, we really need to keep abreast of the technological developments to ensure that we understand the risks that are posed and how we address them. So that's all I was going to say. And I said, it's a fairly whistle-stop tour, but if there are any questions, please do let us know. I'm now going to hand back over to Nikki.
Well, James, thank you very much indeed for putting that in context and getting us started off. And welcome. I think we've had a few more people join us. So very nice to, I can't see you, but very nice to know that there are people out there listening. And there is a Q&A. I'm sure you're all very familiar with Zoom by now. There's a Q&A function at the bottom, and we absolutely do want audience questions, which we will come to at the end of our fourth speaker. I'm going to hand over now to Sean, who's going to give us some practical use of AI and algorithms in the context of a Travers Smith business.
Thanks, Nikki. Hi, everybody. So I just wanted to talk a little bit about our journey at Travers Smith on AI. About 2 years ago, we looked at the market for what we call contract review systems, which is essentially AI systems that help our clients and our lawyers assess risk across contract data. And we looked at various different products and realized very early on that it was very difficult for us to retain any of the AI investment that we had made in these platforms. So if we were training models in their systems, it was very difficult for us to extract those models and take them away with us to different companies. So we decided at that point that we wanted to build our own AI capability, as it were. And we sort of broke down and deconstructed the AI platforms that exist on the market and realized that in terms of IP that sit within those platforms, there's data, there's training, there's the open source machine learning libraries which are available to anybody, and then there's a sort of web application. And we already had the data, and we already had our lawyers, who are our domain experts, our trainers, and we had access to those open source machine learning libraries. But what we didn't have was a capability for our lawyers to do labeling and training. So we started off our journey using Excel spreadsheets, which I'm sure many of you have also done, and realized very early on that that wasn't a practical solution. We had some corruption issues, we hit a limit in terms of the amount of rows. So we built what in 2 years ago was very innovative, which was a labeling platform, that we've called Etitona. And I essentially call it the value capture layer between lawyer and AI, but for any of your businesses, it's the value capture layer between your domain experts and the underlying machine learning model. But it stores the training data in its original form, rather than it just going straight into the model and then you're not understanding the data that is in there. And having read the ICO's AI auditing framework, there's a lot of points in there which are sort of challenges, which I think labeling platforms could address. I just want to talk to a few of them. So for those of you who have got experience with AI, there is a concept of overfitting, which is providing too much data to a model and there's no material benefit for that model because it's seen enough of that data already. When you've got a labeling platform, you can compare the incoming data that you've got to the existing data that you use to train the model, and you therefore don't need to continue to build or improve that model because you can see that you've already got exact data that's in that model. So that's a benefit of having the original form data. Now for us, we don't want to continue to label data because it costs us money, but in a personal data context, if you had personal data that you were processing, that would perhaps mean that you didn't need to continue to process personal data, which is a benefit from having labeling platforms. Around 6 months ago, we built a force majeure review system. So force majeure is a type of clause within the legal context, which allows one or both parties to delay or terminate performance of a contract based on an event like COVID. And with the force majeure system that we developed, we looked at whether or not we needed an AI solution or whether we could find a rules-based system. And for those of you who don't know, in force majeure, the word act of God exists across every force majeure example that we could find. Therefore, we decided not to process that data and train a model, but we just built a rules-based system looking for act of God. And it was a much more explainable, higher quality system, but it essentially meant that we didn't have to process lots of data. So I think the regulators will get a bit aware of that in terms of personal data being processed when the outcome could have been much better or a rules-based approach. And I think labeling platforms, again, support that. The other thing that I think is interesting is data subjects being able to have data deleted. And if you look at any terms and conditions that say that companies can use derivative works of your data. Derivative works are essentially personal data that's been used to train a model. And if data subjects in the future have the ability for derivative works of your data to be deleted, that is essentially the AI model that has been generated. And we think that having the labeled data would allow us to delete the model, delete the personal data if that data subject has an issue with it, and then regenerate the model afterwards. So for us, really, everything leads to labeling, these labeling platforms. There's 2 companies in Silicon Valley that have just come to market with labeling platforms over the last couple of years. We expect it to be a huge industry over the next 5 to 10 years. Certainly at Travers, we're sort of investing in that. And one of the things that, as it's a sort of a growing industry in Silicon Valley, Google have also got a capability in this as well. Tesla mentioned last week that they were building a labeling capability. But at Travers Smith, to encourage collaboration across the industry, we have taken a very unique decision to open source our Etitona platform. So around 3 months ago, we decided to open source it under the GNU GPL license set for any organization who wants it. So if you are listening to this talk and you're thinking, we need to get a labeling strategy in support of our AI strategy, and we don't have a labeling platform, and you've got data all over the place in Excel spreadsheets, then feel free to get in touch with us and either on LinkedIn or through our Travers Smith website, and I will give you access to our Etitona platform, as I say, fully for free. And yeah, that was all from me, Nikki.
Brilliant, thank you, Sean, very much indeed. And you know, for the relevant members of the audience, that's a great invitation from Sean to engage further on this open sourced platform. Now we're going to move on. We've been talking about personal data, so there's no one better to take that challenge on and taking the conversation further than Alistair from the Information Commissioner's Office. Alistair, over to you.
Thank you, Nikki. I will do my best. And thank you also to Vivian and Liv at Travers Smith for organising this, and Catherine at Tech UK as well. And thanks for letting me come and speak today. So today I thought I'd talk to you about why the ICO is interested in AI auditing, what the ICO means when it talks about AI. Then I'll talk a little bit about our guidance on AI and data protection that James and Sean have referenced already. And finally, I want to talk to you about an AI risk toolkit that the ICO is currently developing, a piece of work that I'm leading on, which I'm hoping will be very relevant to the conversation we're having today, and hopefully will help a lot of you on the call assess your AI systems and make sure it's compliant with data protection law. So first, why is the ICO interested in AI auditing? So as Nikki said at the top of the panel today, there are new uses of AI and algorithms every day that we're seeing. So ranging from algorithms used for recruitment purposes to what we watch on Netflix. And in a vast proportion, in a good proportion of these, personal data will be processed, or personal data will be used, or a decision will be made about someone's personal data. And as the data protection regulator, we have a responsibility to regulate how that personal data is being processed. So that's why in early 2019, we started to develop an AI auditing framework. And this auditing framework was designed to give a clear methodology to audit AI systems. And it primarily was there to support our investigations and assurance teams to assess and go into AI systems during an investigation or a friendly audit or something like that. But we also wanted to be transparent and share with the public our thinking and how we think data protection law applies to AI and algorithms. So that's why we've produced the guidance on AI and data protection that we published last July, and why we'll also be publishing a risk toolkit to help you explain our thinking about how you should apply the law to the AI system. So what does the ICO mean when it talks about AI? So there's no one agreed universal definition of AI. And I think if you talk to 3 members of the data science community and ask them the question, what do they mean by AI? They'll come back with 3 different answers. So we've sort of taken a pragmatic approach to defining AI and simply refer to it as an umbrella term for a range of technologies and approaches that often attempt to mimic human thought to solve complex tasks. But ultimately, when you're thinking about how data protection law applies to your AI system, it doesn't really matter about how you define AI. There's nothing in data protection law that defines AI, and so none of your responsibilities depend on how you define AI. So that's sort of what we mean when we say it doesn't really matter how you define AI. What is important, though, is to have a basic understanding of what AI is and what it can do, and also what risks it can sort of create and exacerbate to individual rights. So moving on to more about the guidance on the AI and data protection, as I said, we published last July. So this guidance is designed to provide you with what the ICO considers to be best practice when it comes to developing, designing and deploying AI systems that process personal data. Parts of it also have an interpretation of the law, which may apply to AI systems. So for example, with data protection impact assessments that James touched on earlier, the ICO holds that the law requires you in the vast majority of cases that where you intend to use AI systems to process personal data to carry out a data protection impact assessment, because it is likely to result in high risk processing. We also take a risk-based approach in the guidance, and this aligns with data protection legislation, which also takes a risk-based approach. So what does this mean? This means assessing the risks and implementing appropriate and proportionate controls to address those risks. So what this means for the guidance is that it's not a step-by-step guide for organizations to go through, and once they've completed all the steps, they're 100% compliant. It really means that you need to look at the particular context that you're using the AI system in, thinking about the risks involved, and thinking about implementing appropriate and proportionate controls. And so this is the way we try to structure the guidance. We've tried to talk about the risks to individual rights, how AI can exacerbate or create new risks to those rights, and some possible measures that organizations can take to address those risks. And then I was asked sort of what would an ideal world look like where everyone read this guidance and implemented it. And to give a full answer would go way beyond my allotted time. So I was just going to talk about three things, which is documentation, transparency, and understanding. So as James said, it's very important, I think, to document the decisions you make in, when you're addressing risks and putting in appropriate and proportionate controls. This is not only good for the organization itself, who can share these policies and ways that you're controlling these risks to staff amongst the organization, so that if they do come up with a problem, they can refer to it. But it's also important from an external perspective. So if you do have third-party auditors, including the ICO, that you've got the documentation there to sort of demonstrate that how you are complying with the law. The second thing I think is important is transparency. So this is a big word in sort of the AI literature, and it can mean a variety of things. But I think from the ICO's perspective, transparency means that you're transparent about how you're using people's personal data, what you're using it for, and the likely impacts on them. So it's important that organizations think about how they can be transparent there. And in the guidance, we talk about, as best practice, to publish your DPIAs. So this is just one area where it's not mandated by the law to publish your DPIAs, but it would help you demonstrate how you're being compliant with the transparency principle if you're doing this. And finally, I think understanding is important. So as I was saying earlier, this guidance isn't a step-by-step guide to compliance, and organizations really need to understand what they have in their hands, so what capabilities their AI system is, what they want the AI system to do, and also to understand what the risks are to individual rights, and how to address them. And finally, I want to talk about the AI risk toolkit. So this is going to be a practical tool that is designed for risk practitioners. And this tool will contain risk statements that we've produced from the guidance. And these risk statements are sort of divided into the different domains of data protection law. So there'll be risk statements associated with lawfulness, with fairness, transparency, security, all of the data protection principles. And then for each risk statement, we try to say why AI creates or exacerbates some of these risks. And then next, we also have a list of suggested practical steps that organizations can take to address the risk that we presented. And finally, we want to sort of create a sort of playbook of it as well. So we're trying to enable organizations to think about the level of risk of each of the risk statements that they can fill in, and a sort of work plan that they can use. So like an action column for people to put in what steps they're going to take to address that risk and status of that. So as I say, this toolkit is designed for risk practitioners. So whether it's people in the data protection office or in legal counsel or any role that requires assessing and addressing risk. Another thing that we're conscious of is that this work is being done in parallel with the work of our assurance and investigations team to prepare themselves to audit AI systems, and that we wanted to align these products as closely as we can. So what we've done is we've tried to align the practical steps with some of the indicators that our assurance teams will be looking for when they go out and audit AI systems. So what we hope this achieves is that if organizations use the AI risk toolkit and then they're subsequently audited by the ICO, that there won't be any nasty surprises, being like the ICO saying, why didn't you do this? And you're like, well, you didn't include it in your risk toolkit or your guidance, so we didn't know. So in terms of the timeline for this project, we're hoping to publish a beta version of the toolkit in the next month or so. I think we're still deciding amongst ourselves whether it's going to be a sort of targeted closed publication of it, so we're only targeting specific risk practitioners, but we're also open to the idea of publishing it publicly on our website for people to provide feedback there. But what I would say to the people on this call is that if you're interested in this and want to hear more and want to get involved and try out the risk toolkit, that you can email ai@ico.org.uk for more information, and we can start a conversation there. And then finally, just future plans in terms of once this risk toolkit is published. The ICO wants to start a sort of library of case studies. So Sean's spoken about a particular case at Travers Smith and the sort of controls that they're taking. And we want to sort of build up a library of these sort of best practice and practical steps that organizations can take, so that individuals and organizations can look at this sort of library of case studies and read what others are doing and see whether it's appropriate for their particular context. So hopefully this risk toolkit will be sort of the start of that as well. And that's all I wanted to say today. So thanks, and I'll hand back to you, Nikki.
So thank you very much indeed, and that was really fantastic. And actually, I'm sure we'll come back to both this point about understanding within an organisation the use of AI and algorithms, but also there's already been some questions about obviously sort of the role of regulation, the role of legislation, and again, I'm sure we'll come back to touch on that in a moment. But I'm going to bring in our fourth speaker, Maria from PwC, who's done a huge amount of thinking across these areas, particularly in relation to ethics and leadership and the use of AI. Maria, over to you.
Thank you so much, Nikki, and thank you, Tech UK and Catherine, for inviting me. Today I want to build on the fantastic points that James, Sean, and Alistair made, and talk a little bit about the context of use of AI in the business and why does it matter? Why do we talk about responsible AI beyond being a preferred tagline being used now by all tech companies, supranational and national organization? And what's the role of C-suite, right? Because looking at AI as a major disruptive force that promises a lot of benefits, especially in a business context, it comes with a set of risks, and we don't talk about risks of AI enough. So I'm delighted to hear that ICO is doing very concrete steps towards the education on AI risks beyond the industry like financial services that are quite mature in understanding and handling risk management in general. But in order for us to really grasp the full benefits and the risk of AI, we need to have a top-down approach, not only bottom-up approach. And this is why responsible AI that looks at issues as an end-to-end governance, not just the development of the product, a proper and proactive risk management embedded throughout the life cycle, not just the one-off exercise at the end or the beginning of the project, plus a really proactive embedment or integrating of core ethical principles in the same manner is absolutely critical. But the first, I want to give you a little bit of insight of the state of responsible AI in the industry. At the end of last year, we ran a global survey and we asked a couple of thousand of our clients across the globe, including in UK, how do they feel about AI? What's the state of adoption? How do they think about issues as governance, ethics, and risk? And what we've discovered, surprise, surprise, is, or not surprise, surprise, is that COVID has accelerated the adoption of AI. So if in 2019, we had about 47 organizations that do not use AI, now we went down to 5%. So that gives us a very good range of organizations looking proactively and using AI in the businesses. But with that, I think there's still, scaling AI is one of the biggest challenges. It's only 4 out of 10 companies do scaling AI, and they still struggle to get it integrated in their operation. But things become better and better when we talk about issues as governance and risk. I think we have heard that 4 in 10 organizations now have a strategy that looks at proactively identifying and managing risk across AI operations. While there's no consistent approach to embedding ethics, many organizations in UK, almost 45% of organizations have either ethical principles or boards that will allow them at least to get a grasp of what are the key ethical considerations they need to be aware in their own business. And lastly, again, to our surprise, a little bit, the top consideration among the ethical principle was not fairness or privacy. It was, in fact, reliability and security, which means that businesses are still, to a certain extent, concerned of the quality of the output delivered by AI, while embedding it in current processes that are by no means ready to embrace that disruption. We all know that the key regulatory themes, not just in UK, but across the world, are in fact key ethical principles: fairness, data privacy, accountability, and transparency. So I think it's really important for us to name right those key regulatory principles, and understand that ethics is not a fad or something that only philosophers are tasked to deliver, or it's not only about social justice. It's about real key concern that we all discuss in business, but we name them a little bit in a different way because we go to the next level. The role of the C-suite in handling AI is absolutely critical. So critical that a survey run by McKinsey reckoned that in AI top performance, they are more likely to 2 times more likely to have an exquisite leadership that understands that ethical and responsible AI is a competitive advantage. They will go so far in not only in ensuring safeguarding and increasing brand reputation, but increasing the quality of products developed, attract the best talent, but also work its magic around optimization and performance improvement, which seems to be one of the hottest topic, or it was the hottest topic in business, especially now in the current context. So C-suite, as I said, plays a very important role. But unfortunately, and I'm not shy of saying it, we're not quite there yet. Hence, the work I'm doing with World Economic Forum in creating educational resources for C-suite, where we actually make the business case for ethics of AI, for responsible AI, and demonstrate how this way of approaching AI is beneficial for business. You know, there are also positive events. The fact that the CEO of IBM and other tech companies are being very proactive of talking about responsible AI as the only way of doing AI. But looking at the rest of the industry outside tech sector per se, I think we have a lot of work to do in educating and raising awareness of the issue, and demonstrate to boards and C-suite how a responsible AI is the only engine to growth if we're looking into a truly sustainable business. And lastly, since we are on a event talking about AI audit, in order for us to have a meaningful impact, we have to be able to get our house in order. And getting the house in order, meaning realizing that we have to standardize the development processes, but not only development, use and monitor. Again, AI is that technology that gets us out of comfort zone. And it's not just enough to focus on developing it. We have to create governance structures that come and wrap around that technology that will teach us how to, not only how to work with it, but also how to monitor and being able to correct whenever it deviates from a certain accepted performance. But in order to do that, we have to bring all those different elements together. So we've been talking so much about governance of AI in one corner, about operationalizing ethics in another, and about risk management in a different corner. I think we have to now, it's a time to bring it all together and create some sort of a target operating model for AI, if you want, that looks at things holistically, because AI will challenge us to do that. And in our conversation with our FS clients, right, we might think that they have the highest maturity in deploying and using AI. One of the key challenges was the fragmentation of the organization. The fact that they understand AI requires compliance to work with business unit, to work with HR, to work with data and the data office, but there's no culture in organization that we work together towards a very specific goal. Secondly, looking at all the different ways of approaching or operationalizing ethics, having just boards or frameworks is not enough. We need to be looking at how do we train everyone who works with data or is in vicinity of AI, not just the developers, but very important procurement specialists, right? Because a lot of AI enters in organization via procurement. Hence, organizations are very little prepared to handle being able to assess the tools that are coming their way, but also being able to recognize that AI triggers a profound organizational change. So we need to incentivize those who drive change to be able to make it sustainable. And lastly, I think when it comes again of the notion of AI, is that we need to be very specific on what we audit for and what we audit against. I think having that clarity and also support from the legislator as well will give AI audit or assurance. Again, we need to clarify what's AI audit and what's AI assurance, a lot of boost and a lot of need to make a difference within the enterprise. The last thing I wanted to say, the AI audit market is quite bubbling. There was quite a bit of startups, especially across the pond. They are looking into doing it. One of the main concern is that without the proper regulatory framework, they won't be able to have the impact and hold companies accountable. And I think this is something that we need to keep in mind. We need audit tools because we have already a lot of algorithms. We don't even call AI. They're making an impact on lots of people's lives, not just organizational performance. So we need those audit tools. But once we perform the audit, how do we make sure that the remediation measures are in place and we see positive impact? So we just perform an audit for the sake of it. So thank you very much. I hand over to you, Nikki.
Brilliant. Well, Maria, thank you very much indeed. And thank you to all our speakers. Very thought-provoking, and you've done your job because we've got lots of questions coming in. So we'll do our best to tackle them in the 15 minutes we have available. We said we'd let you all go at 11 o'clock. I should say for those questions that we don't get to, there's a couple of quite detailed ones. We will obviously follow up after the webinar with those who have asked them. One of the questions asked has been about, and I think Maria, you just touched on this really, which is the need for legislation in this space. And I know you're a member of the all-party parliamentary group on AI, and I don't know whether that's come up. Just because it was asked about how aware are our MPs and peers in Parliament to provide a right environment for AI to prosper. I mean, I would say that this is very much, from my experience, it's coming on the agenda. I mean, clearly, obviously, everyone has been busy over the last year, but actually, in a way, the COVID situation has definitely, I think, in terms of data availability and sharing, it's obviously led to lots of questions, but then also, obviously, the use of AI to help with things like, obviously, vaccine and drug discovery and other issues like that. So I think there are pockets in Parliament and in government that are very aware of these issues. There was a national data strategy last year. We're waiting for the national digital strategy. And as I say, I think in the budget or refreshed industrial strategy, we'll hear more about how AI and the use of algorithms can help to boost our economy. But I mean, Maria, I don't know if you have a view on this about, you know, how long do you give regulation, perhaps led by the ICO and others, before you think that legislatures are going to have to step in with some rules around the use of algorithms and AI in a business context, in the same way that Parliament obviously passes the Companies Act, which sets out requirements high level for financial audits, which are then obviously fleshed out by the regulators?
First of all, I want to salute my colleagues from APGGAI, Tim Clement Jones and Stephen Melcalf, for the pioneering work. For the last 4 years, they have been promoting all matters of AI and responsible AI across the two chambers, and they are UK's main policy hub. And I will encourage you to read their reports because they are absolutely fantastic. And you can see the evolution of the narrative around AI since 2017 to the date, and how well informed or not various groups within society that work around AI are. When it comes to regulatory framework, obviously James and Alistair and Sean probably have much better opinion than myself, but from a business perspective, I think there is probably a need to go a little bit step by step and narrow things, right? If you look at something like algorithms, we don't, as we don't have a clear definition about AI, we might not have a clear understanding of algorithms. And when do we draw the line? How much do we audit? Do we go into auditing the data set itself? Do we want to audit the process of data collection? Well, we know that a lot of the bias crippling, but also it's really important to understand that issues like fairness are very context sensitive. So we need to understand at the level of each individual organization and use case, what's the understanding of fairness? And that comes in different ways, one via the legislative frameworks, but in the same time, we can't really impose a certain definition of framework or a fairness or a level because they will not be sustainable. So hence the need for organization to really pick up in defining internally and having policies that will help their development teams, procurement teams, to understand what fairness means in a specific context. And from there, try to build, as I said, blueprints and stabilize the processes where this happens, and work with likes of ICO and FCA and everyone who does regulators work in this field, so they find the common ground. But the way to do it is narrow it down step by step, so we don't impoverish too much the development of AI, but in the same time balance it with managing the risk that exists at the moment. The last thing I wanted to say is that there are a lot of algorithms out there. They are biased, they are discriminate. Let's not hide it in plain sight. A lot of our clients share that with us. It says, we know that we have this issue. We audit then, and then what do we do? Because that will trigger such a profound change in our organization, and we can't really support it. When we put it among all the other priorities to keep the business running in the current economical context.
Yeah,
well, that's a yes. Please, James, go on.
Sorry, Nikki. I was just going to add that I think from a legal perspective, I sometimes have a slight concern with narrowing in on a very, very focused topic, especially one where, as Alistair and Maria have both said, we don't have a definition for. And my main concern would be that we'd end up potentially with a piece of legislation which was trying to hone in and focus on something, but actually missed lots of stuff or was out of date very quickly as the technology moved on. And I think that there is a benefit to the approach that we have at present, which is not looking at the algorithm itself in isolation, but looking at the effects. So looking at the concerns. So on the one side, equality or discrimination or personal data or financial services regulation, that it's a patchwork, but it can serve the purpose. So, but I do agree that there is room for something ancillary alongside that. But it's a balancing act, I think, that we all need to be aware of.
Yeah. Alistair, I was going to ask you about, because Maria mentioned it, about if you had a view on when the ICO might take enforcement action against organisations using AI systems in ways that aren't compliant with the law. And if you want to add anything to points also raised, please feel free to do so.
Sure. Yeah, so I think I'll try and combine the answer to the two sort of previous questions. I think it's important to put into context how fast AI has evolved over the last 10 years, and also how new some of these legislations are. So, for example, the GDPR only came in 2018. The Equalities Act was only 2010. I know that's over 10 years now, but there are still there's still parts of the Equalities Act that hasn't really been tested within the courts. It was only like a couple of months ago that there was a case involving the use of legal, like, positive discrimination and stuff like that. So what I would say with new AI regulation is that maybe it's a bit too soon to start talking about it, and really we need to understand a bit more where the limitations of the current regulation are. Provide sort of soft legislations, whether that's like guidance from the regulators to explain how the law applies to AI systems and stuff like that. So I think that's a more sort of cautious, conservative route to go down, but I think that's probably the most sensible route. And that sort of links to the answer to the enforcement question. Again, I think organizations are still working out basically the risks and the sort of controls and how the various different legislations apply to it. So at the moment, I don't think enforcement action is something that is necessarily the most sensible route for the ICO to go down. And it's more about getting organizations to understand and to implement some of the controls to make responsible, trustworthy AI.
No, thanks very much. Now we had a question, quite a detailed question about insurance, which I think we might answer because James, you mentioned the example of insurance and discrimination potentially on the basis of gender, but just in that there was with the points you made, apply to all services from utilities to banking and e-commerce, with dynamic pricing becoming more and more common. I mean, I think I'm going to put words in your mouth, but we're not just talking about insurance, are we here?
No, absolutely, yeah. The provision of any service, so financial services, leisure, tourism, you name it, it's covered. Yeah, absolutely.
Alistair, we've also had a question, this might be on for you, about whether there is a difference between ethical and legal concerns between public and private sector. I mean, Maria, you might have a view on that as well in terms of the ethics, but Alistair, from your point of view as the ICO, are there different considerations? Would your risk toolkit draw a distinction between public and private sector organisations?
Not one that immediately jump out. I suppose issues around transparency are probably slightly different for public compared to private sector. I mean, the public sector probably have a higher bar for transparency than the private sector. But I think, like, looking at data protection legislation, there aren't like specific rules for the public sector compared to the private sector. I know that there are some in, like, so public sector organizations have to carry out like an equality impact assessment for AI systems, but there's no real equivalent within the data protection context there.
Maria, do you think anything ethical considerations change whether you're talking about public or private sector use?
I think yes. I think there are major changes because most of public talks about the data of the citizens, since it's extremely sensitive data. So in the same category with the medical data, right? So I think some of the biggest consideration obviously are around fairness, transparency, but also privacy. How much data is too much when we look in someone's life? And I think it's worth keeping in mind that government sits on huge data sets. If you look at something like policing or home office, we're talking about extraordinary big volumes of data. And at that level, everything changes. All the rules that we know are not applicable. It's enough to look at the event that happened last year, at the end of last year, with Google and Dr. Timmy Kipper, and the fact that she raised the alarm at the fact that the large language data sets tend to have a different behavior. And this is where we need to be very careful, is because we are talking about personal data of the citizens. And we need to start educating the data scientists to have, to a certain extent, the same due diligence as doctors do when they treat their patient. Just because you don't see someone doesn't mean that you don't affect their lives. At the moment, it's not the case. And I think we really need to change that very quickly, because ultimately we can create the perfect legal framework. But if we don't foster an ethical behavior, those frameworks will be useless. So I think we have to act in different direction. So at the end of the day, we achieve that outcome with AI that protects and helps flourishing everyone in society.
Yeah, and I think that point about ethics, you can have the great framework, financial audit might be the same, but you still need ethical behaviour, and that comes from the top. Now, I'm very conscious of time. I want to put in two more very quick questions, one to James and one to Sean. James, we had a question about businesses taking part in AI auditing. How can they do that while at the same time protecting their intellectual property, both in the model and the training data? How do businesses, and I think also, are you aware of businesses having these discussions?
Yeah, I think it's a really interesting point. So the way, conscious time as well, so it's a very quick answer, but I think the key point that I would say is that I think initially when we're talking about AI assurance and audit, from the legal perspective, I wouldn't ordinarily expect that to be delving into the data sets and the technology itself. From my perspective, from a data protection perspective, or from an Equalities Act perspective, I think that assurance and audit program is looking back at the documentation, the data protection impact assessments, the analysis that you went through to establish that your data set for training wasn't in some way discriminatory or biased. It's a little bit akin in my mind to when you look at a security audit. You wouldn't expect someone coming in to do a security audit necessarily to be able to go into your systems or a counterparty to a contract. It's about high level reporting on penetration testing, etc. So that's how I would see it going, but it's probably one for the future.
Absolutely. And Sean, just very briefly, just in the example you gave, I mean, Travers Smith, Etitona is not processing personal or consumer data, but are there any privacy issues in the model providing something where you're sort of still looking at things that are business focused but are sensitive? What your experiences on that?
Yeah, absolutely. So if you've got an example of two companies merging and they've got confidentiality terms as a legal contract, and that's been used to train a model, then you could reverse engineer that position by sending a confidentiality agreement to the model with those two companies named. And if you get a certain type of output, then that would suggest that there's something happening there, that maybe there's a merger happening and you've got a pre-market position. Now, the way that that's addressed through something called differential privacy is that you cloud the model with lots of additional documents, so it doesn't provide that outcome. But for us, we've built a feature of Etitona, which is called Clause Extender, which allows us to be much more precise on that basis and essentially create 500, 1,000 different soft drink companies and insert those names instead of the two that perhaps we're merging, so that we've got a lot more precision about the model that we're building and making sure that it doesn't provide the inference that people are perhaps looking at. And I think that also goes a little bit to bias. If a model's providing an output that is biased and we want to artificially augment and create a set of data that means it doesn't provide bias, then we can also use our clause extender feature for that as well.
Brilliant. Well, thank you very much indeed. I'm conscious of time. I know everyone's busy in the Zoom world. It's amazing how you can be busy sitting in the same chair for about 10 hours a day. And I want to I draw it to a conclusion. We've got some fantastic questions, and what we're going to do is we're going to work our way through them, and we will liaise with the speakers and get people answers. There's a great one about from I think Josephine Yam about moving from data protection impact assessments to human rights assessments, which I suspect could be the subject of a PhD thesis, probably all on its own. But in the meantime, what I wanted just to do was to draw attention. There's a couple of offers. Sean obviously has offered to talk to people about the Etitona, the labelling platform. Alistair has asked for thoughts on the risk toolkit, and you can email ai@ico.org.uk. We're going to do I think a note from this seminar. I just wanted to say thank you very much, first of all, to our speakers, to James and Sean and Alistair and Maria for their time and expertise. I think we could have probably carried on this conversation for quite a bit longer, which I think is a good sign and great interest. I want to thank everyone at Travers for their help in hosting, but also Catherine Holden at Tech UK, who's been instrumental in putting all this together as well. And thank you, all of you, for being here and being interested. And we will be following up on this because I think, as I say, it's a very fast-moving topic, and clearly there's lots more to come, I suspect, in 2021 alone on it. But for now, I'm going to say thank you very much indeed for your attendance and investment in time today.